Mr. Boies, that you're going to proceed first.
Yes, Your Honor. Thank you. May it please the Court, my name is David Boies, and I represent the Vice President and Senator Lieberman.
Mr. Boies, let me start right off. When the case was here previously in the protest part of the proceeding, no counsel for any party in briefs or in argument raised with this court the U.S. Supreme Court case of McPherson versus Blacker, seemingly because counsel did not believe that it was important for our consideration. However, that case was forcefully argued to the U.S. Supreme Court, and the U.S. Supreme Court has now called that case to this court's attention in the opinion that came out this Monday. And now, once again, no counsel has argued that case to this court, but I want to know from each counsel its importance here. My reading of that case is that the U.S. Supreme Court has said that the state legislature has plenary power, full power, in respect to appointment of presidential electors, and that power cannot be eroded even by the state constitution. Now, accepting that as controlling law, why does that not mean that the courts of this state can only be involved in resolving controversies and contests where the legislature explicitly gives this court that power, or a court that power, which it has not done in respect to presidential electors in 102.168. And secondly, even if 102.168 is read to implicitly apply to presidential electors, why is it not judicial review given to the circuit court and not this court, since the only means by which there is a right to appellate review in Florida is through the state constitution? Would you please address that, and I would like the other counsel to address that.
Yes, Your Honor. First, with respect to whether the appropriate forum is the District Court of Appeal or is this court, the District Court of Appeal has, of course, certified this issue as a matter of great public importance and an issue that needs immediate attention.
I understand that jurisdiction. My question is appellate review, where that is not expressly given in 168.
We would say, Your Honor, that under 168, this court has the power to review both directly because it has been certified up and under this court's mandamus power, which we've also alternatively put forward in our brief.
Where do we get our right to review the appellate review? From the rules and from the Constitution? And doesn't that create a federal question?
I don't think so, Your Honor, because what you're doing is you're reviewing and reviewing in an ordinary judicial interpretation way the statutes of this state. That is, I don't think the Constitution of the United States in any way means that the legislature has to sit both as a legislative body and a judicial body just because an election of presidential electors is involved.
Well, why isn't this like sovereign immunity, where the courts only have such power to resolve disputes and claims that is expressly given to it by the legislature, where if the legislature in this state says courts are not to decide claims in excess of $100,000, those are matters that are taken to the legislature in a claims bill. Why isn't this analogous to that?
Because what I would respectfully suggest, Your Honor, is that the legislature has provided this court with the authority to interpret these laws. That whenever the legislature passes a law, what the legislature is doing is passing a law that is known to be going to be interpreted by the courts. That is, in terms of Section 168, this is a law that the legislature did not say we are only going to apply this law to non-presidential elections. Prior to this case, I don't think anyone would have contemplated that this law did not apply to presidential elections, and certainly no one, not this court and not either party, so contemplated the last time we were